All right, so this is in the matter of the people of the state of Michigan versus Jacob Dean Kelly. We have two files, 23-21287FH and 24-21801FH. I'm Matthew Murphy appearing on behalf of Mr. Kelly. And Mr. Kelly is appearing via Zoom from the jail. So, Mr. Kelly, have you had an opportunity to read and review the pre-sentence report?
Yes, I have, Your Honor.
Right, and have you had an opportunity to discuss that with Mr. Murphy?
I need more time, Your Honor, if we could. I'm sorry to butt in. We need a breakout session. Yes, we need a breakout session to discuss it further.
Okay. All right, so Mr. Murphy and so a jail room too.
Thank you.
Hold on. Yep, just a minute. Okay, go ahead and join that breakout room. I have somebody in jail Zoom 6, but they are not connected, so I don't know. Mr. Glazier, is Mr. Collins in custody?
I don't think so. His mother is here now.
Judge, I don't believe he is. I mean, I just actually met with him last week and got him on drug testing. So I don't think.
Oh, he came in and met with you and he's testing?
Well, he did not meet with me, Judge, and I actually went to his residence and signed him up for testing. That was last week.
But you went to his residence and you got to see him?
Correct.
Has he been testing?
I have not gotten results as of yet.
Okay.
He texted him. This is his mother, who happens to be my neighbor. And he thought he was supposed to be here at 9, but he's just past 9.
Do you want to try calling him?
She's already texted him. If you want to.
I can hold it.
Issue a benchmark, whatever you want to do.
I can hold it for a couple minutes to see if he shows out.
Judge, I'll call over to the jail too, just to verify he's not there.
Yeah. Mr. Raymer's here. Miss Underwood, do you want to take care of Mr. Raymer?
Sure. I think we need a prosecutor. It's a pretrial.
Who's your prosecutor on this one, do you know?
Gumtown. Dan Gumtown.
I think Mr. Sears.
County Jail.
Oh, I called you instead of the prosecutor. I'm sorry.
That's okay.
Oh, I have jail Zoom 6 open. I think we're waiting for Mr. Madison, but they're not connected to video.
Oh, Mr. Madsen in jail room 6. I will.
Well, I mean, I have a jail Zoom 6, but it's like there, but not connected to audio or video.
Oh,
So I didn't know if that was Mr. Madison or not.
You're waiting for Mr. Madsen, and this is whose court?
Judge Anslow.
Angelo. Very well.
All right, thank you.
Okay.
Let's try prosecutor.
Judge, it's Mr. Sears, and I just messaged.
Who?
Nicholas Sears, and I just messaged.
Who's that?
The prosecutor.
Oh. He's not even on my list, so he doesn't exist.
I'll tell him.
All right.
This is Andy. Don't tell me this.
Are you texting him?
Yeah, I just messaged him.
Or Miss Spade's gonna have to review my phone list again. Okay. So we're waiting on a prosecutor.
He's on his way.
All right. Are any of you on in-clan today?
I'm sorry?
Do any of you represent Vincent in-clan for the probable cause hearing at 10 with me? No? Are you Vincent in-clan? Okay. All right. So Ms. Adams, the 10:30 with AG is off, correct?
Judge, I wasn't sure what you wanted to do with that.
Oh, yeah, it's off. I'm fine with that. Well, hi there. All right. So, Mr. Raymer, want to come on up? All right. So, Mr. Sears, you're not yet on my list. So, I'm going to need your P number real quick. So this is in the matter of the people of the state of Michigan versus Shane Leroy Raymer. Leroy or Leroy?
Leroy.
Yep. Okay. I like Leroy. File number 23-21665FH. I have Brenda Underwood, P41009, appearing on behalf of the defendant, and state your, I have Dan Gumto, but state your full name and your P number, please.
Your Honor, Nicholas Sears on behalf of people. Nicholas Andrew Sears. I am appearing under Michigan Court Rule 8.120, I believe, which is the observation of waiting for my bar results.
Okay, very good. All right, you had your hand up?
Yes, I fired her due to misrepresentation
When did you fire her?
over 2 weeks ago.
Was that in front of me?
No, that was in her office but the reason I fired her,
Well, do you have another attorney?
I will represent myself.
You're gonna represent yourself. You know, there's a very famous quote about representing yourself. Do you understand that?
Yes,
That, you know, do you have a law degree?
I don't need a
Do you
law
have a
degree.
college degree?
I don't need a law
Did
degree.
you graduate from high school?
I don't need that either.
You don't need that to represent yourself? Okay, do you have access to, okay, so.
I have evidence that shows that the description did not match and
Well, I'm not gonna get into that yet. So you're asking me today to remove Miss Underwood as your attorney,
yes,
and you want to represent yourself.
if I.
Do you understand that even when I have court cases, I hire an attorney to represent me?
Well, I can't trust anybody in this system in this area because they all seem to be working together. This case should have been resolved a long time ago during the appeal the first time. She should have objected when the claim was made that I matched that description 100%.
Okay, so Mr. Reamer, part of what you're saying shows to me that you don't quite understand how the court procedures work, okay? So your attorney has an obligation to ethically represent you. And so before I would have clients come to me and say, I want you to file this and I want you to file that. And I would say, there's no basis for that. And I don't file frivolous motions, or I would say to them, they have probable cause or whatever. So if you want to represent yourself, you can do that at your own risk. You have the right to represent yourself. But what I will tell you is that Miss Underwood is the bane of most prosecutors' existence, because she's a little pit bull and she doesn't put up with a lot of guff from them, and she's a tough defense attorney. So you may not like what she says, but I feel like she's always honest. So that being said, if you want to proceed and represent yourself, you can. But you understand you're going to have to file written motions. You're going to have to follow the court rules.
This is the trial, right?
No, it's a
Why is-
pretrial.
How is this not the trial? I was told this is gonna be the trial.
This
I'm
is a,
supposed to be facing it. I'm supposed to be sitting here with a jury today.
no, you're not.
Yes,
You're,
Your Honor.
Mr. Raymer, I scheduled jury trials and I haven't scheduled you a jury trial.
I was.
Yeah. Oh, wait, you're the one that didn't show for the pretrial. That's why. Is that why?
Your Honor, if I could speak
Yes.
for a second, I think the first thing we need to do.
I'm
is
sorry.
address The bench warrant.
Yes. So Mr. Raymer, you
Representing Mr.
failed,
Raymer.
yeah, he failed to appear for the pretrial conference.
That's correct.
All right.
I-
So everybody stop talking for a minute. So Ms. Underwood, thank you for reminding me of that. Mr. Raymer, you had a final pretrial conference on December 11th, and we gave you a notice of hearing, and you failed to appear for that pretrial. And because you failed to appear for that pretrial, I canceled the jury trial because it cost me a lot of money to have a jury here. And so if you're not here for the final pretrial, I'm not going to trial until I get you here. So I actually issued a bench warrant for your arrest for failure to appear for the pretrial. Do you understand that? So Ms. Underwood's now asking for me to set aside that bench warrant. Is that what you said?
Thank you, Your Honor. He did demonstrate to the court that he can show up by showing up this morning.
Okay, so Mr. Raymer, so Ms. Underwood's asking me for me to set aside the bench warrant for your failure to appear on December 11th. Do you understand that? Speak.
Yes, ma'am.
All right, and Mr. Sears, any objection to me setting aside the bench warrant since he has it today?
No, Your Honor.
All right, so Mr. Raymer, I will quash that bench warrant, and I'm sorry, I didn't look back to see that this was the original trial date. So that's my procedure. If people don't show up for a pretrial, I set the jury trial as the pretrial, okay? Do you understand that? So that's why
Yes or
there's no
no,
jury.
Yes or no?
I did answer that.
So we're recording, so we have to hear you. So you have to speak up really loud, okay?
I said yes, ma'am.
Louder.
Yes, ma'am.
Okay, so Mr. Raymer, all right. So Ms. Underwood and Mr. Sears, this is a date and time set for pretrial. Mr. Raymer, I have your attorneys did file all the paperwork. Ms. Underwood, do you want to speak to Mr. Raymer for a moment?
Your Honor, I'm not sure that would do any good.
Okay. So
If
Mr.
Mr. Raymer would like to speak to me, I am more than happy to speak to Mr. Raymer at this point.
So I'm going to quash the bench warrant. Mr. Raymer, if you want to sit down and talk with Ms. Underwood and see if you can meet a common ground, I would highly recommend that. You know, if you want to take 5 minutes or 10 minutes and talk to her, you can do that.
She's not been representing me appropriately.
All right. So do you understand you don't get another public defender?
Well, I fired her and I talked to this man. Are you Mr. Glacier?
No, that's Mr. Glazer.
Who was it that was in the office with us?
That was
That
me.
was Mr. Malero.
Okay, Mr. Malero and her why was he in the office when?
'Cause he's-
in the,
All right. So Mr. Raymer, if you are firing Miss Underwood, or I can grant that, but I don't have the ability to appoint another public defender to represent you.
No,
They are a
I-
separate entity.
If I can't get somebody to represent me that's doing the job appropriately, then I will represent myself. Because I can prove that I was not that person that they're claiming.
That's what a jury trial's for.
Yeah, and when it comes to the jury trial, then I will take care of it there. But I don't need somebody that's not gonna represent me appropriately.
Okay, well, I really doubt that she isn't appropriately representing you, but, so Mr. Glazier and Mr. Malaro, he's asking for me to, he's asking to fire Miss Underwood, so,
If I may, Your Honor.
yes,
Your Honor, I vetted Mr. Raymer's claims about Ms. Underwood's representation. My understanding, she conducted a preliminary examination. She also filed a motion to dismiss, I believe, that was heard and ruled on by this court. I have not determined that she's done anything that did not require, or that was not required of her. And so I denied Mr. Raymer's request to appoint a new attorney. For one of the reasons was that a trial date was imminent and it would be almost impossible for any attorney to get up to speed. Ms. Underwood is clearly ready to go to trial in this case. I think, as the court, I think, is aware, Mr. Raymer just doesn't like what he hears. So that is the reason I denied his request to have another attorney appointed in this manner, because Ms. Underwood's doing everything she can do on his behalf.
so Mr. Raymer, I guess I would ask, she held a preliminary exam, which is what you do to dispute the charges, and the judge ruled, whoever heard this, that there was probable cause and bound you over, right? Yes,
Yes. Yeah.
and then she filed a motion to dismiss, is that correct?
Yes, Your Honor.
And I denied that.
Yeah, because you was.
What else is she supposed to do?
You was given false information. All she had to do is object and let it be known that I did not match the description of the person.
That's for a jury to decide.
No, that's for the.
Okay, well, I'm glad that you were trying to explain the law to me. So if you do not want her as your attorney, I will remove her
Yes,
as
I
your
do not want
attorney.
her as my attorney.
All right, so Ms. Underwood, you are relieved of your duties. So Mr. Raymer, you can either hire an attorney or proceed as you are. So I will get another jury trial date. Mr. Raymer, you will need to file with the court jury instructions and voir dire questions. And those are gonna need to be filed by a certain date.
And how do I go about doing that?
I can't tell you because I can't give legal advice. That's why you had an attorney. So you're gonna have to figure that out on your own.
Okay, well.
I can't give you legal advice as a judge.
That's all right.
That's what Miss Underwood was for.
But she wasn't doing her job.
She did do her job.
No, she
But
failed.
I'm not gonna argue with Mr. Raymer. So Miss Adams, I'm looking for a trial date.
Judge, you want me to find the first available?
He's not in custody. It's a one-day trial, so sure, but he's not in custody, so.
First available is April 22nd at 9 a.m.
Does that work for you, Mr. Sears?
Your Honor, that does work for the people.
All right, does that work for you? Okay, so I'm gonna set trial for April 22nd of 2025 at 9 a.m. And I'm gonna set a final pre-trial for Miss Adams. Do I have April 9 available?
Yes, Judge.
So a final pre-trial for April 9 at 8:30 a.m. So was there a plea offer made in this file, Mr. Sears?
Your Honor, yes, there was. Would you like me to place what the offer was?
I always do, yes. I keep that in my file. Thank you.
Your Honor,
You're not on this file anymore. Thank you.
Just 1 second while my computer, it is slow, Your Honor. It looks like the final plea offer provided from my office was 2 counts of an attempted RMO.
All right, so Mr. Raymer, do you understand the plea offer was to plead to 2 misdemeanors?
Yes, sure.
Okay, so those are 1-year misdemeanors, so it'd be 2 1-year misdemeanors in lieu of the 5-year felony, because you have, well, 4-year felony, police officer assaulting and resisting causing injury, and you have 2 2-year felonies for police officer assaulting, resisting, and obstructing, and 1 misdemeanor for disorderly person. Are there any body cams? Were those provided to Mr. Raymer?
Yes, I believe a discovery was sent to obviously the public defenders.
Okay.
If you would, obviously you would need any additional body cams or discovery, we would ask that Mr. Raymer come to the prosecutor's office and receive any discovery that he would want in person. Call ahead and they can get a file.
Okay. So I'm gonna set the final motion deadline for 4/9/25. And then motion in limine for the same day as well. Jury instructions and voir dire questions will be due by April 2nd of 25. And so those must be filed with, you must provide a copy to the prosecutor's office of your voir dire questions and jury instructions, and a copy to the court on the third floor of the clerk's office.
And that can be wrote out on a blank piece of paper?
No, they must be provided in full and filled out.
Okay, where would I go to get those forms?
There, you can do research on the computer.
All right,
I mean,
that's fine.
this is why, Mr. Raymer, when you're dealing with a felony and you're facing trial,
Yeah.
it's important to have an attorney. And it
Yeah,
doesn't sound,
one that's doing their job, yes, I understand that.
well, you haven't presented anything to me that says she hasn't done what she's supposed to do so far. So, Mr. Raymer, you know, there's no legal services available for indigent defendants other than the public defender's office. And, you know, you could hire an attorney, but these things are required. If you don't file them, then you don't get to add them the day of trial. Do you understand that?
What's that, the evidence? I don't get to add any evidence during the day of trial?
Well, you must submit it as exhibits and witness lists. Have you got to exchange those with the?
All the body cam would be considered already submitted, correct?
So you have to provide witness lists and a list of exhibits to the prosecutor's office, to my office, and then you must provide copies of that to them.
And where do I find your office at?
Third floor clerk's office.
Okay.
Okay, but then you have to provide a copy to the prosecutor too.
Yeah,
Okay.
I'll probably head over there for you.
But by law, Mr. Raymer, I can't give legal advice because I'm a judge.
Yes, sure.
Okay. So, Ms. Adams, could I please get a copy of this from Mr. Raymer? And I'm gonna put little asterisks next to everything. Okay, so could I get a copy from Mr. Sears as well as for Mr. Raymer? Ms. Raymer, again, do you want Mr. Raymer's file? Are you sure you do not want to proceed with counsel?
I would prefer to have counsel, but I don't want her representing me.
Okay, well, that's your choice, but your other option is to hire someone. Thank you. All right, have a seat back there and we will get you a copy of your pre-trial notice. All right, I have a jail Zoom open, but nobody's, oh, they put somebody else in. So, let's see. Close that breakout room, bring your client back.
Can we do,
All right, Mr. Kelly is back. All right, Mr. Kelly, have you had an opportunity now to speak to your attorney?
Yes, I have, Your Honor.
All right, I'm gonna put that jail room in the waiting room. And medicine. Miss Adams, you can have these two. Thank you. Okay, all right, and Mr. Kelly, are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, I am, Your Honor.
All right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, we reviewed the prior criminal history and prior history. There are no additions or corrections to make in regards to the PSI.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware of, Your Honor, no.
All right, on file number 23-21287FH on count 1, controlled substance possession of methamphetamine, the probation department has computed the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
On count 2, weapons carrying concealed, they computed the guidelines to be 0 to 9 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
On count 3, controlled substance possession of analogs, they computed the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
All right, on count 4, motor vehicle operating without insurance, that is a 1-year misdemeanor. On file number 24-21801FH, count one, they computed the guidelines to be 2 to 17. Do you agree with that computation of guidelines?
Yes, Your Honor, I reviewed the PRBs, and I do agree with the computation of 2 to 17.
Okay, and then on count 2, controlled substance possession of methamphetamine, they calculated the minimum sentencing guidelines to be 19 to 38 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Kelly?
Yes, Your Honor. And I do apologize. I may end up taking a bit of time, but Mr. Kelly's case had progressed for quite a while. He had the previous case. He was released on bond, and then he had, unfortunately, another case come up. Mr. Kelly, he is suffering under, substance abuse issue, an addiction. Quite frankly, I think that's obvious from the charges. Now, these did pop up fairly quickly, and that is, again, as I expressed, the PRVs on the later charges are because of that. These occurred after he was sentenced on another case that was out in Hillsdale, before the other case before Your Honor was worked out. Now, Mr. Kelly, we had him screened for recovery court. He was a good candidate for recovery court. He didn't qualify for Lenawee County because he wasn't a resident of Lenawee County. His last residence was in Jackson County, right over the county line. We had him screened in Jackson County. Jackson County Recovery Court say he doesn't qualify. He's not a high risk, high needs person, so they rejected him. And again, I discussed with Ms. Teskey about it again over emails. He doesn't qualify for Lenawee County because he isn't a resident. He doesn't have a residence here, but he doesn't have a residence anywhere, Your Honor. He doesn't have an address other than the Lenawee County Jail. So it was a situation where I was getting kind of frustrated because I believe, looking at Mr. Kelly, that's what he needs is recovery. He needs to go into an inpatient rehab. He needs to be given these tools. It's unfortunate that it's gone this point in his life that he has that's flared up, that he hadn't been able to address this sooner. But as we see that a lot of people don't address it on their own sooner than coming into the criminal justice system. So again, Mr. Kelly, he deeply regrets the situation that led to this. If you look at the instances, you look at the previous incident in Jackson, it's all fueled by the substance abuse issue. Again, obviously, I have concern about Mr. Kelly serving a period of incarceration, not having the proper tools when he's done with that, however long that period may be, to go back out and I don't want him to reoffend. I want him to have the proper tools. I would ask the court to consider, I understand that the guidelines, I think it would be asking the court to deviate below the guidelines on the later charges, but to ask the court to consider giving him a year in jail, maybe credit for time served and suspending the remainder to have him go to an inpatient rehab, maybe Dawn Farms, some intensive place that would be more beneficial to him and a better use of resources. I do understand, again, with the seriousness of these charges, with the guidelines being as they are, Mr. Kelly definitely understands as well, and he's here to accept any punishment the court gives. But again, he does have a support system. His boss, Mr. Rose, had contacted my office quite a few times over the length of this case, expressing a desire to help any way he could. Of course, he couldn't change the charges that Mr. Kelly was facing. He couldn't ultimately do much of anything other than express his support. Mr. Kelly's sister had contacted me as well. Unfortunately, she was not able to have him reside there in order to try to help in regards to meeting a residency requirement. But he does have individuals that are there to support him. Unfortunately, obviously, the big issue that he's had to deal with is a substance abuse issue, which, again, people who are under the thralls of these tend to push away other individuals. So, again, at this point, Mr. Kelly still has some people that are willing to a support system. So I would ask the court to consider deviating below the guidelines and maybe, again, sentencing him to a period of 1 year incarceration at the jail. And then after that, to release to inpatient or for 1 year and then suspending the further with inpatient treatment. But again, Mr. Kelly will abide by any order the court gives for a sentence. So thank you, Your Honor.
Mr. Kelly, all right, do we have, so Mr. Kelly, you haven't been sentenced on your violation of probation in Hillsdale County yet, or you have?
Correct, Your Honor. I have not. I go back February 3rd.
Okay. Okay. Is there anything you want to say on your own behalf, Mr. Kelly?
I just want to thank Mr. Murphy for representing me, and then the court and Your Honor for your time and patience. I've struggled with addiction for a while, and I'm ready to make a change. So I'm appreciative of the opportunity.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence and are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. Mr. Kelly, you have just a long history of addiction. You're right, you do, and you need help. I'm looking to see. You know, I know you've been placed on probation in other counties. You were released to residential treatment back in Hillsdale back in January of 23. Did you complete that treatment or did you take off?
What do you mean by residential?
I show back on January 6th of 23 in Hillsdale County. No, it says Jackson County. They gave you 120 days. It looks like on a violation of probation and released you to residential treatment. And then on it looks like July 2nd, probation revoked. Did you ever go to a rehab program?
No, Your Honor.
Okay.
Your Honor, I'm sorry. I thought later in the report it had mentioned that he wasn't able to because of the pending runaway.
Yeah, the pending felonies. So, all right. All right. So it's sentence of the court that on file number 23-21287FH. You'll be placed on probation for a period of 3 years. Will serve 1 year in the Lenawee County Jail. I'll give you credit for 270 days already served. If Jackson or Hillsdale County or whoever you have out there pending wish to send you to an intensive inpatient program, we will allow you to be released to attend that program. Do you understand that, Mr. Kelly?
Yes, Your Honor.
Otherwise, you will serve the year in jail. There's $130 crime victim rights fee. There's 3 felonies plus 1 misdemeanor.
So the 23 case, a total of 254.
Yeah, so it's $68 on each count for a felony and $50 for the misdemeanor, for a total of $254 in state costs, $30 per month supervision fee, $60 if we have to put a tether on you. And obviously wherever you land is your probation can be transferred there within the state of Michigan. On file number 24-21801FH. I'll give you credit for 269 days already served, 3 years probation. Obviously that can be transferred wherever or transferred here, depending on where you live. On that file, if you're given inpatient treatment through any other county, you can be released to that program as well. And there is a $130 crime victim rights fee. No, yeah, crime victim rights fee and $136 in state costs, $68 per count. So Mr. Kelly, you are hitting rock bottom really fast. And so I'm hoping that one of the other counties, when they sentence you, will now be able to send you to an inpatient treatment program. That's why I'm doing this. I'm giving you one more chance. You know, at this point, you're just hurting yourself and emotionally and mentally hurting your family. But, you know, I hope that if you are admitted into an inpatient treatment program, understand you will be ordered to enter and complete that program as a term of your probation here. If you take off or get kicked out, that would be a violation of your probation. And then you will be looking at a prison term. Do you understand, Mr. Kelly?
Yes, Your Honor.
All right. So am I missing anything, Ms. Holly?
Court costs?
Oh, yep. On file number 23-21287FH, I will assess $750 in court costs.
And we should probably do the no weapons in the search.
Yeah, and you must obey and comply with all terms of probation, not to drink alcohol, you're not to use controlled substances, not to commit any crimes, not to have any weapons in your possession. Ms. Holly can enter your house at any time for probation supervision, but she also, if she has reasonable cause to believe that you violated your terms of probation, she can search your house, your car, computer, whatever. So I don't think there's any restitution. I think that's it. So, Mr. Kelly, we're going to send over to the jail your notice of right to appellate review. There'll be a copy for each file. Initial and date, one copy for our records. They'll get that back to us so we know you received it. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. So that's my Christmas present to you, is that on this file, you're not going to prison this time, but if you violate, understand I won't have a choice.
All right, thank you.
And you should report to me first Tuesday out.
Okay, so when you get out,
Yes.
you have to report to Miss Holly that first Tuesday. So if you get out at Tuesday morning at 2 a.m., you got to report to Miss Holly. If you get out on Wednesday, the following Tuesday, you need to report to Miss Holly. Don't use any drugs when you get out. Start going to programming or whatever. If you get transferred to an inpatient rehab facility, make sure a message gets sent to Miss Holly so she knows where you're at. All right.
All right.
All right. Good luck to you. Thank you.
Thank you, Your Honor. Thank you. Thank you,
Mr. Kelly. Yeah, if you need any questions, just write or try to call me, okay?
All right, thank you.
Thank you.
Thank
you, Your Honor.
Thank you. Okay, so. All right, Mr. Madison, I'm sorry, I put you in the waiting room because booking is always kind of loud. All right,
Yes,
so
ma'am.
this is in the matter of, it's our pickup. This is in the matter of the people of the state of Michigan versus Brandon Madison, file number 23-21242FH, 24-21996FH, and 24-21997FH. I think your dad was here earlier, but it's been a long morning, Mr. Madison, so I'm sorry. So I am covering this file for Judge Olsaver. So,
Okay.
Mr. Madison, we have a motion affidavit and bench warrant on each of these files, a contempt of court for failure to appear for a probation violation hearing on December 11 of 24. That contempt of court can carry up to 93 days in jail. Do you understand that?
Yes, ma'am.
All right, and then the underlying request and summons for probation violation alleges that on November 12th and 19th of, hold on a second, I'm trying to find the little post-its. Judge Olsaver keeps track of his files differently than I do. You failed to report to the probation department on November 12 and 19 of 2024, and your whereabouts are unknown. So do you understand that's the allegation against you for a violation of probation?
Yes, ma'am.
All right, now on file number 23-21242FH, you're on probation for police officer assaulting, resisting, and obstructing, causing injury. So if you plead guilty or found guilty, you could be facing up to 4 years in prison. Do you understand that?
Yes, ma'am.
All right, and then Judge Olsaver's files are much better organized than mine. Okay, and then on file number 24-21996FH, you have the contempt of court that carries a maximum penalty of up to 93 days in jail. And then you have the violation of probation for, oh, no, that is a failure to appear for a pretrial on November 27th of 24 at 8:15 a.m. So that's a contempt of court for failure to appear, and that carries up to 93 days in jail. Do you understand that?
Yes, ma'am. Miss Angelona, all this stuff extends from like, I got sick, I caught COVID, right?
Mr. Madison,
Yeah.
hold on a minute. I gotta go through and read you your rights, and then I gotta go through and find out who your attorney is. So then on file number 21997FH. We have a couple things. One, we have a failure to appear for a pretrial November 27 at 8:15 in the morning. So that carries up to 93 days in jail. And then we have a contempt of court from Darren Coast, my pretrial services coordinator, that states that you failed to drug test on October 22nd and October 29 of 2024 for pretrial services coordinator. And that you, when they tried to reach you by phone, they were not able to, and your voicemail was not set up, so they were not able to leave a message, and that's another 93-day contempt of court. Do you understand that, Mr. Madison?
Yes, ma'am.
Now, Mr. Madison, who is your attorney on your new felony files?
It's Matt Murphy.
Matt Murphy. All right, Mr. Murphy, do you represent Mr. Madison on those files?
Your Honor, I do represent Mr. Madison on the new felony files. I'm sorry, I wasn't paying attention to why we're here today.
You weren't paying attention to me, Mr. Murphy?
I didn't have any cases left scheduled, but yes, I have Mr. Madison.
All right, so we have contempt of courts for failure to appear for November 27 pretrial, as well as failure to drug test with Mr. Coast. And then he has a VOP on a previous file that he's on probation for. So, Ms. Underwood, perhaps Mr. Murphy will just handle these for you.
I'm sorry.
Mr. Murphy, do you want to handle Mr. Madison today?
Yeah,
So that Ms. Underwood?
Yep, I can handle these.
Mr. Murphy's going to cover these.
Thank you, Your Honor.
Thank you, Ms. Underwood. All right, so Mr. Murphy, so we have a contempt of court on each file for failure to appear. And then we have a contempt of court. Two of them are failure to appear for a pretrial. One is failure to appear for a probation violation hearing. Probation violation is for failure to report, and that's on a 4-year felony. And then failure to drug test with Mr. Coast on the new files. So Mr. Murphy, do you, Ms. Adams, can you email that paperwork to Mr. Murphy maybe?
It's done, Judge.
God, she's amazing. So, Mr. Murphy, do you want to break out room with your client?
If I could, Your Honor.
Okay.
Thank you.
All right. So let me open a breakout room, and Mr. Madison, I am going to put you in a breakout room with, let me find you. There you are, with Mr. Murphy. All right. Okay, so Mr. Glazier, with regard to Mr. Collins, you're on Mr. Collins, right?
Yeah, he's not here. His mother's texted him. He did respond on a text that he thought he had to be here at 9, but I don't know where he's at.
So in the matter of the people of the state of Michigan versus Darius Dwayne Collins Jr., file number 24-22082FH. This is the date and time set for arraignment in this matter. Mr. Glazier, thank you for your patience this morning. This matter was set for 8:15 this morning. It is now 10:31, and I know that his family was here and reaching out to him. He thought he had to be here at 9, and that was well over, an hour and a half ago, and he's still not here. So, Mr. Glazier, I guess at this point, I can give you a week to try to reach him, or I can issue a benchmark.
If you want to turn it over, we'll try to.
Miss Adams, when is my next available pretrial date, or Wednesday available, Miss Adams? Like a week or two?
Your next available Wednesday is January 8th.
Find out. I got a Christina in my waiting room. Let me find out who she is. You said January 8th?
January 8th. Do you want this scheduled with Olsaver or with you?
Yeah, he's back that day. I'm sorry, this is a Judge Olsaver file. So it would be January 8th in front of Judge Olsaver. at, what time does he do them? 8:15?
I believe
All
so.
right. So we'll set this over for rearrangement on January 8th at 8:15 for you to try to reach them. Obviously, Judge Olsaver at that time can determine what he would like to do. Mr. Glazier, I did receive an amended information that added the habitual offender. Did you receive that?
I don't know. I'm
Judge,
sure.
I apologize. We're on Collins, correct? I
What?
think that
Collins.
I
Oh,
think
wait.
that is yours. I'm sorry. That's my
I'm sorry, it
mistake.
is mine. I know I have something for Judge Olsaver. All right, so that'll be in front of me, rearrangement on January 8th. And Ms. Adams, can we mail a notice to Mr. Collins?
Of course.
I think we have a, all right, so rearrangement at 8:15. All right. Okay, Mr. Glazier, thank you.
Judge, for Mr. Collins, I just received results. They did test on the 22nd. He was not on that list, so it appears he did not test on the 22nd. But I'll get you a letter right before the 8th.
Okay, thank you. All right, thank you, Mr. Glazier.
All right, thank you, Your Honor.
So,
I need.
all right, we got Mr. Christina. I have somebody on an iPhone named Christina. Can I ask your full name, please?
Yes, it is Christina M. Austin.
Give him the round.
All right. Can I ask what case you're here for?
I'm here for the Nikki Cleveland Brown.
Yeah. Miss Adams, I probably gave you that file back. All right, that's at 11 o'clock, so I'm just gonna put you in the waiting room, okay?
All right, thank you.
Thank you. All right, we're back with Mr. Madison. So, and Mr. Murphy, this is a Judge Olsaver file, by the way. I know I had one this morning. So, Mr. Murphy, have you had a chance to speak with Mr. Madison?
Yes, Your Honor. And speaking of Mr. Madison, because these are Judge Olsaver's file, we just asked the court to continue not guilty plea on them and set it for a pretrial in front of Judge Olsaver. And then Mr. Madison was asking to address bond in the matter.
Okay, the next available pretrial for Judge Olsaver is January 8th at 8:15 in the morning.
We could set it for that date and time, please, Your Honor.
Okay, is that right, Miss Adams? He's back that day?
Yes.
Okay, all right, so Mr. Murphy, you may address bond.
Your Honor, Mr. Madison's cases before you right now, his failure to appears. He had been communicating with myself. He was texting my personal cell phone quite a bit, and then my number changed, and I tried to reach him through the office, reminding him moving forward, you know, with my number changing, you need to contact the steady number of the public defender's number. I haven't heard from him in a couple of weeks. He indicated, and we had expressed this before, I talked to Mr. Coase about this, that Mr. Madison had gotten sick. He believes he had COVID. I don't know if he's gotten the documentation to Mr. Coase, but since then, Mr. Madison had gone to the hospital again. He says they found a mass in his brain, and that there's more tests that have to be done to see if it's cancerous or not. Because of that, he has had some issues, focusing on what that means ultimately. He does apologize. He did have a lapse of memory in regards to making court dates. He has indicated, though, obviously he's available right now to test. If Mr. Coase wants to have a test arranged, he'll provide obviously a drug test sample right now to show that he has no illegal substance in his system right now. Again, Mr. Madison, in the past, we understand this is for not appearing. However, in previous cases that I've had Mr. Madison on, he's turned himself in when he's had outstanding warrants. On one of these cases, the newer felony, he had for an entire morning The district court had wanted him to go over to the jail to get fingerprinted. He went over to the jail, waited for a couple of minutes. So it ended up taking a few hours of Mr. Madison's time running back and forth from the jail, then to APD, try to get something done. And again, he was following all the tasks at that point. So I don't believe that this is a matter of him trying to flee the jurisdiction. From my understanding, he was obviously, there wasn't a new charge that brought him into custody. The police went to his house and arrested him yesterday on Christmas Day. There wasn't a fight, wasn't a struggle, it wasn't any, from my understanding. Again, he didn't come to the court, turn himself in, but it wasn't a new charge. So I would ask the court to consider giving him a PR bond on these. He got on the date of January 8th to appear before Judge Olsaver. Again, he's available for testing if need be right now. So he's asking the court to consider is giving him a PR bond.
Mr. Coast, at any time was he in compliance?
No, Judge, he's been terrible at doing the drug screening. I actually set him up for drug screening on October 15th. He was supposed to see me every Tuesday, failed to do so. I've not seen him since October 15th. I actually been out to his residence before. He doesn't return phone calls. He did mention that he did have COVID and went to the hospital. I requested documentation. He has not done that. So because of his inability to follow directions, my suggestion is to leave the bond alone. And we could go before Judge Olsaver on the 8th.
All right, I'm going to deny his request for bond, and you can address it again with Judge Olsaver on January 8th at 8:15 in the morning. I don't believe, based on his activities in all three files, that I do believe he's obviously not going to show up. So, all right, thank you very much, Mr. Madison. Judge Olsaver will see you back on January 8th at 8:15.
Thank you for your time, Your Honor. Considering bond.
Thank you. Thank you. Okay.
Was there anything else or?
Yeah, you have Mr. Funds. Let me see.
Yes.
Hold on. So, Collins, right? No, who are you hearing?
Conway. You don't have a case for it. A case already heard on there.
Okay.
Speak to you because she's on Zoom.
No. Okay, that was Boykins, right? She never appeared on Zoom.
No, they just told me to send me a link. It's only a
He's already been sentenced.
Yeah, I know.
Okay, so Mr. Murphy, I had Fonseca.
Yeah, show cause for Arthur Fonseca.
Yeah, so this
Somebody
is in the
not-
matter of the people of the state of Michigan versus Arthur Lewis Fonseca, file number 24-22013FH. I have a motion, affidavit, and or order to show cause. Mr. Fonseca test positive for cocaine, fentanyl, xylazine, which is Mr. Coast had told me about xylazine about a year ago, and it looks like it's finally hit our county. So he tested positive for those on December 2nd and December 9th, and those were sent out and confirmed positive by forensic fluids labs. And he has not appeared today. Do you know where he is, Mr. Fonseca?
I don't know where Mr. Fonseca is. I haven't had any communication with him. I apologize, Your Honor.
All right, so I will issue a bench warrant for failure to appear. It was set for 8 o'clock this morning. It's now 10:42. And I will set bond in the amount of 50,000 cash surety. All right.
Thank you, Your Honor.
Mr. Murphy. Obviously, if you hear from him, let us know.
I will, Your Honor. Thank you. Everyone have a
Thank you.
good morning.
You have a good day too. All right, so Mr. Inclan, I need to find a prosecutor. And, oh, let me go find the prosecutor. Let me just,
Do you have no criminal?
no,
Okay, if you need.
I mean-
I'm here if you need me.
okay, no, I think we're done with that docket.
All
This is a district court matter. So, all right, Mr. Inkland will be with you in a minute. I'm gonna go find a prosecutor. That's not a prosecutor. Do you want him back for the attorney? So Mr. Doug will let him back. Wait for the other.
It's Adrian, so. Well, it depends on whether or not it's technically on the side of the jury, the prosecution. So should be that side. So I'm also on that side. How are you, Miss Spade?
Good, good. How are you?
I am excellent, I
Good,
suppose.
good.
Did you have a wonderful holiday?
I did.
Yeah,
I did, yeah. It was really nice. Yeah, how was yours?
not long enough.
Oh, they never are.
And the girls are getting to an age now that they don't just hang out at our house all day.
Right,
You know what I
right.
mean?
They're out and about.
Well, they get up, they have breakfast, do
Sure.
things, then they're like, well, we've got to go to our boyfriend's house.
Yeah.
But,
It was really nice to meet the girls.
Yeah.
It was really nice, very nice. Made it extra special.
yeah, well, they're special for sure.
Yeah, definitely. Very nice.
There ain't no way we're getting through this here today.
On one, but
Yeah, well, it's never on.
yeah, no.
Right back in.
All right, thank you.
Good. My hearing did not go that long by a miracle, so.
I guess.
Well, anytime you do a Zoom, like I do from home, and then you come here, and you gotta get in your car, you gotta drive over, so I just assumed I was gonna be late.
Want to talk?
Sure.
Lucia,
Do you want to go in the back?
Yes.
Okay, sure.
Hi, Joey.
Hi, how are you?
Merry Christmas.
Merry Christmas.
How have you been? I'm gonna have to have a hug. When do I ever not get a hug from you? Oh,
Can you drag me here on? I didn't get one either.
I will. You insisted on in-person Zoom. I
Damn
did it in my
right.
pajamas and zooming into my home.
I insisted because this is.
Please rise for court now session.
We can do this real quick.
Okay, yeah, I can do this real quick.
Yeah, I'm gonna need a date.
Okay.
Okay. All right, Mr. Inclan, you want to come on up and then I'll call the case. Okay, just go stand at that podium for me. All right, this is in the matter of the people of the state of Michigan versus Vincent Matthew Inclan, file number 24-2619FH. This is a date and time, looks like set for a probable cause hearing. I have Nicholas Sears appearing for the Lenawee County Prosecutor's Office, and Mr. Inclan, okay, Mr. Inclan, you do not have an attorney?
No, ma'am.
Are you going to retain an attorney?
No, Your Honor, after, I'm gonna represent myself.
Did you request court-appointed counsel?
No, I did not.
Okay, do you want to be screened for court-appointed counsel?
No, ma'am, I have a feeling that this is kind of gonna wash down. And I'm
Well,
just
we
gonna
all, Oh, okay, so Mr. Inkman, we can have a lot of feelings in life, but that doesn't mean anything.
I've been in and out of the courtroom for a while.
But Mr. Inkman, what I'm saying is, do you want to be screened for court-appointed counsel?
No, ma'am.
All right, so you wish to proceed representing yourself?
Yes, Your Honor.
All right, Mr. Inkman, I always say you have the right to do that, but I will tell you, anytime that I've been involved in a lawsuit, I have hired an attorney.
Yes, sir.
Okay, so, because, you know, obviously you don't have the legal training, so, Mr. Sears, has there been a plea offer made by the people?
No, Your Honor, this is Mr. Sneed's cases, and upon reviewing it, does not look like there has been a plea offer made by the people. But procedurally today, it's set for PCC. We're probably gonna, kind of quick review of the file, we're gonna request another PCC. It looks like the victim has called the office this morning, wants us to reach back out to her this morning. So I think at that time, in the interest of justice, we would want to set a new adjournment, the next court date to a PCC, so we can reach out back with the victim in this matter, see what she wanted to call us about, and then we can proceed going forward. So,
All right. So do you understand, Mr. Inkman, the prosecutor's office is asking for this to be set for another probable cause hearing so that they can speak with the victim in this case? And then, do you have any objection to me setting another probable cause date?
No objection. Your Honor.
So, Ms. Adams, have we already set January 2nd at 9 a.m. for the preliminary exam?
No, Judge, it was my understanding that that would not go.
Okay.
That was
So,
so.
So what I would like at this point is probably just to set it on a Wednesday, late morning. So, and Mr. Inkland, I'm gonna get a date for that, all right? So Ms. Adams, I'm looking for maybe if we can do 10:30 or 11 on a Wednesday, my next available. I know it might not be for a couple weeks. Do you have any objection to that?
No.
Okay. Okay, thank you.
Judge.
I just, we're kind of, or if you have something else, Ms. Adams.
Well, we really don't. We have jury trials on all these Wednesdays, but I'm looking at.
Can I do it on a Wednesday? A probable cause, we could treat it like with the rest of our pre-trials. Do I have like a January 8th or 15th?
I'm gonna say the 15th probably best.
Okay, how about January 15th at 8:30?
Works for people here.
All right, so that'll be a probable cause, so it'll be a quick hearing, and then if we need to set a preliminary exam, we'll set it at that time, okay?
Yes.
And you have no objection to January 15th?
No objection.
All right, Miss Adams, do you want me to do a scheduling order, or are you able to generate a notice?
I cannot generate a notice, but I can pull up some kind of generic form.
Well, I've got my little scheduling order, so let me do that, and then we will get you a copy of that, all right? So just have a seat. And
January 15th.
yep, I'm gonna get you a notice though. So let me write this in. And then we'll go get you a copy of it. Right, January 15th. Okay. All right, so we're gonna go make a copy of this for you. And then we'll get you that and you're all set, okay? Thank you, Mr. Sears.
No problem, Your Honor.
Thank you very much.
I will join. No problem. Yeah, with me seeing that, she called this morning. Give him a
No, no. Okay.
Okay. So it seems. Okay. Okay. Okay.
Okay, but they just don't want to go drive.
Yeah, I've had my fair share of driving on.
Okay, take
Thanks,
care.
Ryan.
You're welcome, Nick. Good to see you. Got it?
Yeah.
Oh, no.
we're done till. Why am I working so much this week? I don't even know. You're killing me. I was like, well, I have some days off. Nothing.
You need me, Judge, or no?
All right, I have in the matter of, go here, I don't know, Wade Cleveland versus Nikki Cleveland, file number 2017-43733 DM. So I have in my room, I have admitted a Christian Simons, a Christina Lofton, a Matt Muckle, and then I have somebody on a Galaxy phone. I've asked you to unmute. Can I ask your name on the Galaxy? What's your name, please?
Mary Lang.
Okay, so I thank you all for your patience this morning, but we will not need you to testify today. So thank you very much.
Oh, perfect. Okay, great.
Thank you.
Okay.
Thank you.
Thank you. Happy New Year.
Happy New Year.
Bye.
Happy New Year.
Happy New Year.